Chair and members. Without the hyperbole of everything that's been said about AB5, I just want to spend a moment to take you back to how we got here. In April of 2018, a unanimous bipartisan Supreme Court decided that the number of cases that they had seen on misclassification was overwhelming. And that in order to deal with that, they were going to create a test that was much more simple for misclassified workers to understand the law. They felt it unfair that through the Borello test, which is an 11-point test that weighs factors, that a worker could never really determine their classification unless they actually filed a lawsuit. With that, they said, it's clear. There's an ABC test. We're going to make it easy. And they provided no exemptions, but a lot of rationale. There was a lot of fallout from that decision. We started hearing from businesses who were concerned that they were using legitimate independent contractors or having a business-to-business relationship, but were getting caught up in that decision or would be subject to a lawsuit because of that decision. We started hearing from writers who had lost jobs from out of state because of that decision. And we knew that there were those of us who really wanted to protect the workers that were protecting that decision, and at the same time make the clarifications necessary that it worked for as many legitimate independent contractors and small businesses as possible, yet preserving the fact that misclassification become a huge issue. We passed AB5 last year, and as soon as it was signed, we started hearing from individuals who felt like they were caught up in the language. We also heard from individuals who we knew that we were going to have to make changes for. We had said that as it went forward. So here we are with 1850, which is the bill to provide relief for individuals in individual areas that really did get caught up. I introduced it in January to continue the work we started to protect workers, responsible businesses, and taxpayers against misclassification. And as we find ourselves amidst of a global pandemic, the need for AB5, the impetus for Dynamics decision, could not be more clear. Making it more difficult for employers to misclassify their workers upholds the social contract entered into by employers, employees, and the state. This ensures that while frontline workers risk their own health every day on the job and millions of American Californians suffer financial hardship, families are able to depend on a safety net during these times. Properly classified employees are able to rely on the state's social insurance programs, including unemployment insurance, disability leave, and paid family leave, in addition to critical workplace benefits such as paid sick days, workers' compensation if they contract COVID-19 on the job, strict health and safety standards, and protections against retaliation. During this pandemic, we've also witnessed how detrimental the economic impact of misclassification can be on law-abiding businesses and taxpayers. Companies that misclassify their workforces have not paid into our unemployment insurance fund, which has further contributed to the fund's insolvency and led our state to become the first to borrow funds from the federal government to address our deficit. Those who were around during the last loan know what happens in 2 years when that loan becomes due. Law-abiding businesses will in fact have to pay more to cover that loan. Meanwhile, those who have not paid into our system are costing us. The UC Berkeley Labor Center estimated that if rideshare companies like Uber and Lyft had paid into their fair share into the UI fund, they would have contributed over $413 million on behalf of their workers for the last 5 years. Perhaps then we wouldn't have to seek a loan. The National Employment Law Project nationally has estimated that the undue burden placed on law-abiding businesses in form of increased unemployment insurance taxes annually is over $830 million because of the gig economy, and increased workers' compensation premiums, $2.5 billion. That gets borne by law-abiding companies. It's unfair, and it needed to be changed. This is one of the reasons the legislature passed AB5. But when it passed, we acknowledged that there was still work to be done. There were complex issues, there was breakdowns in talks, and it was going to be a multi-year effort. Many people describe this as the largest labor law reform that we've had in decades. Naturally, it's going to take time to iron everything out. Every bill we do in this committee irons something out that has been missed, that has been overlooked, that needs to be fixed. And this will as well, and that's what we're trying to do here. Instead of applying the stricter ABC test across the board, AB 1850 is consistent with AB5 by recognizing that individuals who legitimately operate their own independent business can continue to do so and be governed under more lenient classification tests that we found in Borello. In AB 1850, I've made clarifications that provide greater certainty for musicians, writers, and certified translators, photographers, multimedia professionals, professionals providing risk management and appraisal services, expert judges who determine outcomes for competitions, specialized artists who teach master classes, and others. The process of crafting reasonable clarifications for each industry has been consistently informed by the principles found in the Dynamex case itself. Individuals with significant autonomy and bargaining power in the workplace, individuals who hold a professional license regulated by the state or otherwise work in industries with higher barriers to entry, in industries without a pervasive history of misclassification, have a lesser need for protections against exploitation. However, we know that all independent contractors do not fall into this category. Data from 2019 from the Franchise Tax Board indicates that nearly 650,000 independent contractors qualified for the Earned Income Tax Credit, which has costed taxpayers over $118 million. This means qualifying individuals, these independent contractors, come from single households with adjusted gross incomes of less than $15,008. They are not truly self-employed businesses. They are, in fact, the working poor. To avoid compromising protections under AB5 or imposing weaker standards for workers who were misclassified before Dynamex, AB 1850 tries to strike a balance. This legislation ensures workers who are subject to undue control and direction from employers retain protections under the ABC test, while still clarifying that individuals operating as true businesses entities can be governed in the previous Borello standard. As I continue to implement feedback from affected stakeholders, I intend to work on broadening the definition of referral agency to distinguish the business structure from that of a labor broker, clarify the means by which an organization can rely on content experts for specialized projects, clarify the ability for performing artists to present their original work without restrictions, make changes to language on translators, and look at approaches to address some of the issues raised by interpreters, and further address any ambiguities that will help promote compliance by hiring businesses. Today, I'm going to be joined by two workers who hopefully will be on the line. Their experiences highlight why it's so important that as we continue to make reasonable clarifications to the existing law through AB 1850 for true business entities, we must ensure that any changes do not jeopardize the critical protections misclassified workers just secured through AB5. Mike.
Line 149, 149, please go ahead.
Hi, this is Lisa Rothstein Benson. I'm a California S Corp owner and a freelance business consultant, writer, and cartoonist. I represent the Lollipop Guild of disenfranchised California freelancers everywhere. Like AB5 1850 picks winners and losers. There are still too many losers. I oppose this bill until amended, especially as regards small arts institutions, language workers, videographers, and business-to-business consultants, to name just a few. Thank you.
Thank you.
Thank you, Mr. Chair. Assemblywoman, obviously we're dealing with AB5 again, and I think we're going to deal with it for a little while as we work through some of these exemptions. But I do want to address something that I find a little interesting, and there's a lot of bills that dealt with AB5, I think 15 to be exact, that were not set through this committee on the Republican side of the aisle. But one in particular, and I bring it up because we've heard a lot about it today with interpreters, with translators. It was AB 2979 VOPEL that would deal with this issue. So I guess from my perspective, as we move forward with dealing with this, what is the best way to work with you, the author of AB5, the Labor Committee as a whole, to try to address some of these nuanced businesses that have been sucked into AB5 that I don't think that you are knowingly or wanting to hurt, right? I mean, I trust that. But there is a lot of just businesses that get pulled in that we kind of sucked into this vortex that is AB5, and we need to now work through that. And you've stated that a number of times, like we're working through this. There is going to be fixes. But I am concerned a little bit because we did have significant amount of Republican bills that dealt with exemptions that were important to our districts, that our constituents asked us to work with, including one that dealt with interpreters and translators. So I guess it's more of a statement and genuinely wanting to figure out a way that whether it be the ag community, whether it be interpreters that quite frankly I don't know a lot about, it's not my industry, but I'm very sympathetic and I'm glad to see that you're all here today. How do we work through this process in a way that, do we come to you with these ideas first? And through what lens are we picking? And I know the term winners and losers has come up a lot, and I think that's a little bit harsh, to be quite honest with you, because I don't think that that's your intentions. But how do we pick, and through what lens are we viewing the business community as it relates to some of these industries that have been sucked into? Because I am concerned that where we're opening up our business community for litigation, for problems, and that was not the intention of this legislation. So I guess that's just my concern and just dealing with that.
Sure. So I will say to you what I have said, and I think people, even Republicans on this committee, have come to my office multiple times with these issues, so that, worked with their constituents, worked with anyone who has come to express issues. I've been very clear about how we look at all of these businesses. So when you say winners and losers, sometimes if we're picking if you consider a business a winner, then the workers are the losers. And so we have to be very careful how we address this. Interpreters and translators have been some of the most difficult to deal with, and I'll explain why. We do have translators that we're trying to get into the bill now. We have a problem with certification. We have the Dynamex decision that lays out clearly the types of things we need to look at to avoid exploitation. And we try to look at it through that lens. Well, one of the things we did is we checked with EDD on past misclassifications. 4,111 interpreters have been deemed misclassified in the last 5 years. 4,111 people, individuals who through the EDD process were deemed misclassified under Borrello. And so that's one of the factors we look at. It's really hard to say, oh, you're all independent contractors, you're still under Borrello, and so now you still have to go through all this process and sue. Or do we look at it and say, okay, what's causing this conflict where some interpreters want to be independent contractors, some do not? Why are some companies required to make them employees by EDD and an audit, and others are not doing that, right? Translators, which do written documentation, we didn't find misclassification suits again, so we were trying to put it into the bill. Now, we wanted a certification so that it fit the other things we talked about. If you're a translator, what makes that barrier to entry higher? Certification. Well, and some translators came to us and asked us for that. Well, then we find out that there is no certification except by one group, and it's only for Spanish, and so we're leaving out a lot of people that we didn't mean to leave out. That creates a whole nother issue. We allow people to be translators just because they assert to speaking the language, and so the barrier to entry becomes very low, especially in a state like California. We have a lot of multilingual people, and so it's ripe for exploitation. We're working with translators, but that's there's not the level of control. You do it from your home. We're not worried about workers' compensation. You set your own hours, all of those things, right? Interpreters are special, and we're trying to figure out how do we stay true to the Dynamex ruling, and we have done that. I appreciate people say winners and losers and random exemptions and that to me, I get it. If you haven't spent, I guess, the last 3 years looking at this case, looking at all the misclassification cases, looking at all these agencies' misclassification suits under Borrello, talking to all of these workers, then it does look random. But there was nothing random about the things selected. We have been systematically going through them and trying to figure out. With interpreters, we're still trying to figure out how can interpreters work under a referral agency where it's a true referral agency and not a broker, a labor broker. That seems to be the difference, right? How much level of control, how much money is that person taking out of your wages in order for you to do your work? Are you truly an independent, your own small business? And I want to remind people, one of the things we did in this bill is we took the business to business exemption and we put it at the top, because that's the first thing people should look at. And that is very clear. You can be a sole proprietor, you can, be a corporation, you could be an LLC, and if you satisfy those terms where you truly are acting as an independent, and a lot of translators right now and some interpreters are working under those conditions. That's the first thing, that you might not even need an exemption. But with the interpreters, we're continuing to try to have these conversations. Is there a standard? Is there the certified interpreters? Is that different because they have a different ability? And in my own community, I can tell you, we use a lot of interpreters in my community, as you can imagine, right? There is a set of interpreters who work not only as interpreters, but they're also hiring other interpreters, and there's a hierarchy. So if you get to the end of the hierarchy, the last interpreter hired, who's been hired through a broker and then hired through this person, they're getting very little money for what they're doing. And those are the interpreters that came to me and said, please don't exempt interpreters. So it's a balance, and we're trying to get there. We're going to get there on some, but to suggest, oh, somebody who said, I heard from this interpreter, so I want a full exemption, I did kind of find that offensive, because I have been working on this and I know the rhetoric and I know the things that have been waged, but you guys also know me. And I'm not blaming you, but like, come on, I'm not just picking powerful lobbyists. Like, that's ridiculous. Some people who didn't get exemptions had very good lobbyists. Some people who got exemptions had no lobbyists. We actually tried to do our best, and we're continuing to do it by looking at the case law, looking at past practice and misclassification under Borello. A worker should not have to go through hoops and hoops and hoops to prove misclassification when they're clearly misclassified. That's what this bill was supposed to do. At the same time, people are truly their own business we're trying to take care of. So I'm going to continue to work on it. If there's a particular issue, any member, even if they're total jerks to me out in public, can come to my office. I have never denied a member a meeting, ever. And some, Republicans as well as Democrats have come and spent a lot of time with me on these. So I welcome you. I welcome anyone who has these issues. And I just ask that you walk through the decision, the court decision with me. I ask that you walk through the legitimate reasoning that we used. And see, okay, how did we end out this way? And how do we narrowly sculpt this so we don't have workers laying out there who are the losers? That's what I worry most about.
And make no mistake, and I appreciate that. And I think, my concern is that you kind of touched on it, is you made the statement that you're going through this systematically. And I think that's for us, and for me personally, I've been vice chair of labor since I've been elected. And it's a great committee to set on to address these issues. But I want to, and maybe this is a conversation for you and I to have offline, of what is that systematic approach that we're going through, right?
Okay.
Because I do think that while we're dealing with these issues, there may be industries out here that are just kind of just left out here floating,
Sure.
that run into trouble, and it's not really the intention of what we want to deal with, right?
Absolutely.
And I understand what you're doing with the misclassification, and I am going to be supporting this bill today, because I think it's important that we go through AB5 and start putting the pieces back together again under not with protecting employees as well. So anyways, Chair, appreciate your time.
And just, just for an abbreviated version, because I know a lot of people are watching this and they don't understand. So we took the Dynamics ruling and all the rationale that they used, and they talked a lot about barrier to entry into a field. And so we talked a lot about that. Do you need a specialized degree? Do you need a specialized certification? Because when you add those on top of just being an individual, you're less likely to be exploited, because it's harder to get into that. For example, doctors and lawyers. Everybody said, well, why did you exempt them? Well, historically, you can't just wake up one day and say, I'm a doctor, right? So we know that they have the ability to negotiate for themselves. They have control over their own ability to negotiate and their own work. That's an important feature. It was an important feature under Borello, having control of the job you're doing. If you're truly an independent contractor, historically, that's what it was. We looked at past wage orders, right? So there are existing wage orders that have exemptions for folks. That's how we got commercial fishermen. I mean, where would I come up with commercial fishermen? Well, that's been in the law for 60 years as a wage order. So we went through all of the wage orders to say what had already been gone through and why these special circumstances kind of existed. And there are a number of wage orders out there that we tried to line up the bill with. And then we went through past misclassification. Have people historically been employees, and businesses are now just making them independent contractors, and so they're losing rights under kind of some new form of what we believe an independent contractor is. We all the way through, and most folks, you can kind of, when you go through that, you get stuck, right? You're like, and that's why I said when I got told last night, like, hey, a constituent emailed, let me explain to you certification for translators. It's only in Spanish. Okay, that's a problem, right? Because we want to try to get translators who act independently the ability to do that. But suddenly you're telling me there's no barrier to entry. What is that barrier then? Can anyone be a translator? Because if not, you're going to have a labor pool that's extremely large and thus vulnerable to exploitation, right? So I'm trying. I don't want anyone to lose money. I don't want anyone to lose their wages. I don't want to mess up anybody's small business, but we also have to ensure that this is pure to the decision. It's pure to, the history of these professions. And, it took a long time to get to music. That's what's one of these things. That took the unions, the independent artists, the record industry, and it was a lot. But we're committed to doing that work. I think picking exemptions and just throwing them out there is not the way to go if we want to withstand, as we have. And I just want to point this out because the photographers and journalists said, they have a lawsuit. Well, that lawsuit was thrown out by the courts, as has every lawsuit been challenging AB5 except truckers, and that was a preemption suit. And so that's fine. It's on appeal to hear the lawsuit because the judge in particular says AB5 doesn't directly regulate or prohibit speech, but regulates the employment relationship, and that is legal under the California Constitution, the U.S. Constitution. So, but we want to not be random and give random exemptions, and so that's why we go through this process, and why I think it was a little offensive for people to be introducing bills without going through the same process the courts went through, that our legal system goes through, that our agencies go through, and that historically California has already established. Thank you, though.
Thank you.